All right, good afternoon, everyone. My name is Kathy Purdy. I'm a marketing manager here at Schoeneck King, and I'd like to welcome you to this week's coronavirus webinar. Just two quick housekeeping items before we get started. Please submit your questions through the Q&A box located at the bottom of the screen, and we will do our best to address those as time allows. And if you would take a moment to complete the brief survey once the webinar has ended, we would appreciate that, as well as our attorneys and presenters look at your suggestions for future topics. So your input is appreciated, and we do review those. So to start things off, I'm going to hand it to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. It's good to be with you again. We've got a full program today. Quick reminder here, effective April 1, the Putney Twombly folks will be joining our firm. We're excited about that, and we're going to have them on in the coming weeks, so you can get to know them. The bond folks can get to know them, and we can get to know some of their clients as well. So without further ado, let's move on to DJ Nugent. DJ is an associate in our Syracuse office, specializing in employee benefits. And we've had a lot of questions about the COBRA subsidy. So we thought DJ'd give a little bit of a review of what we talked about last week and then focus some on the tax credits. DJ?
Thanks, Pete. Thanks, Kathy. So I'm going to talk about the mechanics of the ARPA COBRA subsidy tax credit. So just as a brief overview, the COBRA subsidy is part of the American Rescue Plan Act of 2021, also called ARPA. It was signed by President Biden on March 11th of this year. And essentially what the subsidy does is between April 1, 2021 and September 30, 2021, 100% of the COBRA cost is subsidized for assistance eligible individuals. Assistance eligible individuals are COBRA qualified beneficiaries whose COBRA qualifying event was either an involuntary termination of employment or a reduction in hours. Assistance eligible individuals must also be eligible for COBRA during the subsidy period and must also elect COBRA. The ARPA COBRA subsidy provisions also contain new COBRA notice requirements that must be satisfied, and also discuss how the COBRA subsidy premiums will be reimbursed. And that's what I'm going to focus on today. Next slide, please, Kathy. So the ARPA COBRA subsidy is a 100% subsidy paid for by the government for those assistance eligible individuals. But the way that it's structured is that employers, plans, and insurers essentially act as an intermediary between the government providing those subsidies and the assistance eligible individuals who will receive those subsidies. So employers will be reimbursed for every dollar they provide to their employees and other qualified beneficiaries as part of these ARPA COBRA subsidies. So ARPA says that 100% of the subsidy is reimbursed through a credit against the quarterly Medicare hospital insurance payroll tax, which is a 1.45% Medicare payroll tax. And that reimbursement also includes the 2% administrative fee. So typically when an employee or other qualified beneficiary is on COBRA, they're responsible for 100% of their premium cost for COBRA, as well as a 2% administrative fee. Employers will be reimbursed for all 102% of the COBRA premium costs that they essentially advance to their employees as part of this ARPA COBRA. Next slide, please, Kathy. ARPA does provide some information on how these tax credit reimbursements are going to work. And what ARPA says is the credit is claimed by, quote, the person to whom premiums are payable. And ARPA gives a little bit of an explanation on what that means. And it says it means the employer with respect to single employer plans that are subject to the COBRA requirements of ERISA, the Code, or the Public Health Services Act, or that are self-funded either partially or fully. It means the plan with respect to a multi-employer plan, and for all other plans, it'll mean the insurer. And these other types of plans are these small plans that are solely subject to state continuation laws, like New York's mini COBRA law. So essentially how this works is the way that ARPA is set up is the entity that the premiums are payable to for COBRA continuation coverage will advance that sum of money to the employees or qualified beneficiaries, and then be reimbursed for the amounts that they advance to the employees or qualified beneficiaries from the government through this tax credit on the quarterly Medicare tax. We're hoping to see some guidance on if there's going to be any nuances on how that works, if maybe there's other entities that are responsible for collecting the premiums, where as opposed to maybe paying those COBRA subsidies out. So that's just something to keep an eye out for, if there'll be any guidance on those nuances. Next slide, please, Kathy. ARPA also provides that the credit cannot exceed the Medicare hospital insurance tax reduced by any CARES Act and FFCRA credits taken. And it also says that the credit may not be taken with respect to any amount taken into account as qualified wages under the CARES Act or as qualified health expenses under the FFCRA ARPA. This is another area where we're waiting to see some guidance issued on how the CARES Act, the FFCRA, and ARPA are all going to relate to each other and how those credits are going to be. But the good news is ARPA says that if the credit exceeds the quarterly tax, credit is refundable. Again, the government is providing a 100% subsidy for assistance eligible individuals for their COBRA subsidies during this time period. And employers are reimbursed on a dollar by dollar basis for any amounts that they advance to their assistance eligible individuals or qualified beneficiaries. So that's what this tax credit refund is getting at, is that if the credit exceeds the quarterly tax, the employers will still be made whole through the refund. ARPA also understands that they're putting employers in this intermediary position, and that could cause some issues due to timing. They have to advance the payments at one time and then get reimbursed at a later date on their quarterly Medicare tax, payroll tax. So ARPA includes this provision that discusses the advancement of credits. That's really all ARPA says, is that this will be allowed. There's no details on how that's going to work. It's just that the departments, the DOL, the Department of Treasury, the IRS are instructed to issue guidance. So another area where we're waiting for guidance to come out on how that advancement of credits is going to work. ARPA also provides that an overstatement of the credit is treated as an underpayment of taxes. So the takeaway there is it's important to make sure when we get guidance that these credits are done correctly, because if we do it incorrectly, it's going to be treated as underpayments of taxes, and there's going to be possible penalties, fines, assessments, those types of issues. Next slide, please, Kathy. So unfortunately, based on what's been issued in ARPA, that's really all we know right now. We haven't seen any guidance come out as of yet. So we've talked about some of the areas that we're still going to wait for guidance to come out on, and ARPA itself directs the agencies to provide guidance on a variety of topics. And this includes, but is not limited to, the timings and mechanics of claiming the credit. Like I said, there's potentially some delay between employers essentially advance the amount of the COBRA subsidy to their assistance eligible individuals and then are reimbursed for that amount advanced, how that timing is all going to work when their reimbursements need to be submitted, and also just the mechanics of how that's going to work, what forms are used, what information needs to be provided. We're still waiting for guidance on how all of that. The other items that the agencies have been essentially tasked with providing guidance on is any method of verifying the correct amount of the reimbursements, how these credits will be applied to multi-employer plans, how we're going to provide for the reconciliation of advanced credits against the claiming of the tax credit against the Medicare tax, and also whether these credits will be allowed to third-party payments. So I think the takeaway for today is the reimbursement is 100% paid for by the government, but through the employers as an intermediary, and that can create some timing issues. And there's going to be guidance issued hopefully soon that addresses a lot of these questions. So that's pretty much all I have for.
So DJ, just one follow-up. Given that it's 100% reimbursement, and you did mention the timing issues, it seems to me the big thing here is the administrative difficulty of administering this, tracking people down who may be eligible, who no longer work for us, and making sure that we get all the paperwork correct. Because it ought to be cost neutral in the end, other than the administrative burden. Is that a fair summary?
That's a fair summary. In outside of the tax credit, just the general ARPA COBRA subsidy requirements. There's no specific penalty in the statute for failure to abide by the ARPA COBRA subsidy. So our understanding is that would be subject just to general COBRA penalties, failure to provide notices timely, other ERISA obligations that can arise.
Okay, thank you. You may win the award for most acronyms of the day. We'll have to wait and see whether Stephanie can outdo you here when we move on to her topic, which is also an ARPA topic, the family leave and sick leave tax credit provisions. So Stephanie's been following this and reporting periodically on these provisions, and we're really going to focus a little bit more today on how the tax credit provisions work. So Stephanie, take it away.
Thanks, Pete. I don't know if I'll have more acronyms or about the same, but here we go. So I'm going to take you guys back. If you recall, the Families First Coronavirus Response Act, that initial COVID relief bill that came out shortly after the pandemic hit, required covered employers to provide emergency paid sick leave, which I'll refer to as EPSL, and expanded family and medical leave, EFML or EFMLA. For a period of starting April 1st through December 31st. And covered employers was defined as having fewer than 500 employees at the time that the leave is taken. And all public employers were also required to provide this leave. And it was for a variety of COVID-related qualifying reasons. The leave mandate expired on December 31st, but there's an extension starting December 27th, after the December 27th COVID relief bill, the Consolidated Appropriations Act. It extended the availability of the payroll tax credits that were available. If you recall, they were a dollar for dollar payroll tax credit for most covered employers. I say that because governmental or public employers and their quote unquote instrumentalities were not eligible to claim that tax credit for that paid leave that they were required to provide. So flash forward to January 1, we have this new Consolidated Appropriations Act that extends the availability of the payroll tax credits to those covered employers. So still just the employers who previously offered or were required to offer the FFCRA leave with an option if they voluntarily extend the leave benefits through March 31st, they could continue to claim the payroll tax credit. The nuance being that there was no extension on the allotment. So if an employee had already exhausted all of their leave under the EPSL or the EFMLA, they did not get any additional leave that an employer could claim tax credit for. And the tax credit was only available to those employers who were able to claim the tax credit in the first place. So unfortunately, government employers and their instrumentalities, public employers were not able to claim the tax credit at all after that either. Next slide, please. So now the ARPA changes, effective April 1st, so Thursday, these go into effect. There was I call it an extension and an expansion of what's available. So there's 3 new qualifying reasons for leave under both the EPSL and the EFMLA for which payroll tax credits can be claimed. Again, this is only for those covered employers who were initially required to provide the FFCRA style leave. So if you did not fall into that bucket, unfortunately, this is not something that you can take advantage of from a tax credit perspective. It's still totally voluntary and it's not a new mandate, but it extends the payroll tax credits for this new period of April 1st through September 30th. The 3 new qualifying reasons are for obtaining COVID immunization. So if someone goes and gets their COVID vaccine, that could be claimed. You could recover the wages that you pay for that paid leave if you offer the EPSL or EFMLA extension. To recover from any injury, disability, illness, or condition related to COVID-19 immunization, so the side effects that many are seeing after the first or second vaccine, or to seek or while awaiting the results of a diagnostic test for or a medical diagnosis of COVID-19 when the employee has been exposed to COVID-19 or the employee's employer has requested such test or diagnoses. So they clump this into that original number 3 of the EPSL qualifying reasons for which leave could be taken and that corresponding payroll tax credit can be claimed. It also applies for EFMLA. Next slide, please. So it expands the EFMLA. ARPA also expanded, if you recall, EFMLA was only applied when an employee needed to take leave to care for their child, if that child's school was closed due to COVID, or if childcare was otherwise unavailable because of the COVID-19 pandemic. It expands the definition of EFML to now incorporate all of the EPSL qualifying reasons, and plus those 3 additional new reasons. It strikes the 10-day unpaid leave waiting period. If you recall, previously the first 2 weeks of EFML were unpaid before that 10-week of paid leave period could kick in. So it effectively permits all 12 weeks of EFMLA to be paid, and the corresponding credits to be claimed, of course, if an employer chooses to extend the availability of EFML benefits. It increases the amount of EFML tax credits that are available for employers. So it increased the limit on the tax credit for paid family leave wages that could be claimed up to $12,000. Before it was up to $10,000 at $200 per day. And then it resets this paid sick leave provision. So if you recall, EPSL was a 10-day sick leave bucket or 2-week sick leave bucket for those qualifying reasons. If, like I said earlier, from that first renewal of the extension, January 1 through March 31st, if an employee exhausted all of their EPSL benefits, that was it. The provision in the ARPA provides a reset. So employers who choose to continue to offer EPSL benefits can reset the 10-day limit for paid sick leave starting April 1st. So those employees would have a whole new 10-day allotment. It does not add 10 days to whatever remaining balance they may have. It just resets it and refills their bucket, proverbially speaking. Next slide, please. So on this slide, I'm not going to read every provision, but this is the breakdown. So if you recall, for EPSL, they were entitled to paid leave at a regular rate or the applicable minimum wage for the first 3 qualifying reasons. And then for the last 3 qualifying reasons, they were eligible for paid leave at 2/3 of their regular rate. Now, all of these reasons can be taken, right, for the if you choose to offer the EPSL extension or EFMLA. Next slide, please. In addition, there's 2 important conditions on claiming the tax credit benefits. Notably, employers are subject to this non-discrimination provision that was included in the ARPA language. Employers cannot claim the tax credits if they discriminate in favor of highly compensated employees. Full-time employees are on the basis of tenure with the employer. So in other words, you have to offer this to all of your employees, not just full-time, and not offer it to part-time employees in order to claim it. And the leave must meet any requirements of the EPSL or the EFMLA. There's an additional provision in there that makes it clear that you have to comply with any requirements of the law, either the EPSL or the EFMLA. And we're interpreting that to mean that you can't cherry pick the qualifying reasons. We've had common and frequent questions about, can I just offer the EPSL for vaccine leave and none of the other reasons and claim the credit? Based on our current understanding and our reading of the statute, it seems to be that you have to pick or you have to offer the leave as is under the EPSL or the EFMLA. You can't cherry pick the reasons for offering the leave and claim those tax credits. That said, next slide, please. And I'm actually getting ahead of myself a little bit. One other minor change from the ARPA language, it extended it, as I said earlier, governmental employers, including their instrumentalities, those public employers, were not eligible to claim the tax credits. The ARPA snuck in a provision that carves out this exception for 501c1 and 501a organizations to now claim the tax credits. This is a narrow exception from my understanding. 501c1 are organizations created by an act of Congress, so it really opens the door for federal credit unions, but not many other governmental or public employers. Whether or not an entity is a governmental employer or an instrumentality of the government is subject to a 6-factor test that the IRS has in their guidance on their website. So if there's some discrepancy as whether or not you can claim the tax credit because you're not sure if you're a public employer or an instrumentality of the government, be sure to check on that 6-factor test. Next slide, please. So some of the common questions that we've been receiving: does an employer have to offer both EPSL and EFMLA in order to claim the credits? Based on our current understanding and the way that the provisions are drafted, they treat them separately. So it appears to be that you could offer just EPSL or EFMLA and claim those corresponding tax credits for paid leave provided under those provisions, as long as all of the other requirements are met. Again, we're probably going to see IRS guidance and DOL guidance on other what that means. What does it mean to meet all of the requirements? Or if they issue any additional guidance that suggests that you have to meet XYZ requirements in order to claim the tax credits, we'll be on the lookout for that guidance. Does an employer have to offer the leave benefits for the entire period of April 1st through September 30th to claim the tax credits? Again, based on the way that it's written in our understanding of the law right now, there's an argument to be made that it does not have to be offered for that entire period. That said, it could be subject to change if the IRS comes out with guidance that says that you do have to offer it for that entire period. Does an employer have to reset the 10-day EPSL allotment to claim the credits? Again, based on our reading of the language and our understanding right now of how it's drafted, it seems to suggest that it's a cap of what can be claimed by the employer. So it does not suggest necessarily that you have to reset that 10-day allotment. However, again, that could be subject to change depending on if the Department of Labor or the IRS issues guidance that says that you do have to reset that EPSL bucket in order to claim the tax credits. So more to come, I'm sure, as we get guidance, and we will be sure to keep you up to date.
Stephanie, thanks. I mean, I think that last point is a good one. We've seen guidance that has caused us to question, scratch our heads a little bit and say, that doesn't appear to be how the statute reads. So, and that's both at the state and federal level. So we'll just have to wait and see. Those are our best reads at this point. So let's move on to vaccinations are a question that we have been getting repeatedly, various iterations of this. So we thought we would review where we've been and also what the latest is. So to do that for us is Andy Bobrick.
Great. Thanks, Pete. Good to be with you. Good to be with everyone here. I guess before I get started, I should tip my cap to DJ and Stephanie for those great overviews. I got to tell you, when we get these statutes and you print them out, they look like phone books. There's so much paper. For those of you who remember what phone books look like in that age. So, hey, kudos to both of you for just a great job on those overviews. Pete did ask me to talk a little bit about vaccinations. I'll be pretty quick today. There's not a ton new that won't be covered either by Katie or already in the course of Stephanie's presentation. Again, the question that we get and are continuing to get is some formulation of, hey, can we mandate our employees to get this vaccine? And again, at least when we're talking about private sector employers here in New York, there is guidance from the EEOC that would indicate, but doesn't expressly give an affirmative positive response, but indicates that, yes, that type of mandate would be possible. Again, there's a number of considerations that still need to be weighed and certain requirements that need to be carefully followed, not the least of which is how to handle a situation if you were to have a mandatory policy where an employee raises their hand and says, hey, I have a sincerely held religious belief, or I have a medical condition that prevents me from receiving the vaccine, and how you handle that situation. Again, we have affirmative obligations under the law to reasonably accommodate the employee in those circumstances. What that may be is going to be a facts and circumstances type analysis. And again, my takeaway for you here is there's no cookie cutter, one size fits all answer to that situation. What do we do when I raise our hands? It's going to require us to take a step back and evaluate that particular circumstance. And given how developing these issues are, and that we're dealing with a very dynamic environment, I would encourage you to work with your bond attorney to address those issues. Also, if we have a collective bargaining agreement in place, you need to consider, is there a duty to bargain with the union before we implement a mandatory policy? What types of rights have we reserved ourselves under the labor contract? And PS, remember too, this is a very dynamic area of the law. We've got the Biden administration now, obviously in the White House, and in that entity will be setting labor policy, obviously in a much different way than had been set under the Trump administration at the National Labor Relations Board. Additionally, there can be certain considerations that need to take into account in the public sector that aren't necessarily relevant in the private sector. You're going to be a state actor here, making certain requirements, so there can be constitutional issues that need to be considered and carefully weighed. And frankly, there's I think the threshold issue that you should really look at is a practical one, right? Should we do this? Perhaps we can do this, but should we do this? Is this the right thing for our employees? Inevitably, you're going to get some pushback from employees on this for a variety of reasons, and all of them aren't necessarily driven by a sincerely held religious belief or by a disability. How are you going to handle that situation? And as a practical matter too, although we're seeing, as I'm sure Katie's going to talk about, the criteria being expanded for who can receive a vaccination, it's still not everybody as we stand here today. But again, take a look at your particular business. Does everybody have to get vaccinated, given the concerns? Are there targeted groups? Are there people who are going to be in the field at customer or client locations? Maybe there's a narrower line that can be drawn there that makes sense. Again, verification, in short, that's something that's been confirmed on a state level as well as on a federal level that, yes, you can, as a general matter, request an employee to provide you with verification of the vaccine that's been received. Again, we have a statute in New York that provides paid leave for employees who are seeking COVID vaccination, and up to 4 hours per shot, as you're familiar with. I mentioned the expanded FFCRA that Stephanie just talked about, because there's also now this enhanced benefit that employees can receive paid time off. Again, if you're an employer who qualifies for the FFCRA, your employees can receive paid time off for vaccination. One benefit of that is that there is a tax credit that's provided for the paid time off, and that credit's not available under the state law. And if you're providing that federal benefit, that may effectively moot the need for the state law leave. And of course, you're going to be reimbursed on your taxes for that benefit. So there could be an advantage looking at this to participate voluntarily in the FFCRA. Again, something you're going to want to evaluate, but you should look at it and consider it. Finally, I'll just mention one concern that's been out there in the past is the approval process that the FDA used for these vaccines, and all three of them that we have now here in the US and that we're receiving, is known as their emergency use authorization. Probably heard that mentioned before, EUA. And in short, it's not the usual process that the FDA uses to approve a vaccine. It's a different, shortened process. And as part of that, people who receive the vaccine have to be advised that they have a right not to receive the vaccine if they don't want to. This is translated into a question as to, okay, well, if an employee, for example, has the right not to receive the vaccine or has to receive that notice, can we still require the employee to receive that vaccine as a matter of policy? And again, our best read of the information that's out there, and again, this is a somewhat novel issue and there's limited guidance, but our read thus far has been, yes, we think that's the best read of the sources of authority and guidance available. Interestingly, there was a lawsuit filed in federal court in New Mexico addressing this very issue. It was an employee who was being required, this employee worked for a public sector employer, was being required to receive the vaccine. This individual did not have a sincerely held religious belief or disability that prevented him from receiving the vaccine, but nonetheless objected and filed a lawsuit challenging the public entity's authority to require the vaccination because of this exact EUA issue. That case is still pending. It's one we're going to keep our eyes on, and we'll be looking at others as well that are out there, but just kind of keep that tucked away in the back of your mind as something you need to keep track of too. Pete, that's what I have.
Thanks, Andy. I think you hit most of the questions in the Q&A. So Thanks for that. Let's move on now to Katie Anderson with the latest from Albany. Quite a bit going on as usual.
The latest and the greatest from Albany. That's right. Yeah, I'm happy to be back this week. So let's get started. We have a lot to cover today. First up, looking at COVID cases in New York. There is a very concerning spike that's happening. Very steep spike in the past 7 days, but really over the past 14 days, we've seen a 45% increase in the number of cases in New York State. New York State currently has the highest growth in cases, has the second highest positivity rate behind New Jersey. So not a good trajectory to be on, despite all our progress in vaccinations. You know, I hate starting a presentation with bad news, but the rest of the, this is important for people to know. COVID is still spreading. COVID is still very much a threat. And this spike is mostly downstate, but it really is across all of New York State. When you look at a map of what's happening in every county in New York, pretty much every county in New York says extremely high number of cases. So that is dangerous. And why that's so dangerous is we have 4 really infectious variants now in New York State, one of them being our own homegrown New York variant running around. All of them are more contagious. And that is concerning. Again, I repeat this every week, but the more time, the more increase that we see in spread of the virus, the more likely it is that a variant will develop that renders a vaccine ineffective. That's why it's so important for everybody to still continue social distancing, continue wearing masks, all of the things that we have been doing for a year, even if you're vaccinated. It's still extremely important to continue to be doing that, as we can see from that chart. The good news is that 30% roughly of New Yorkers have received their first shot. 15.2% are fully vaccinated. Great news. That is great. And every week I've been showing you this chart as well, this graph showing when we're anticipating that the population will receive at least one vaccine. Every week I show it to you, the numbers, the dates come closer to us. So the dates, the last time I showed it to you was May 15th for 50%. Now we're at May 9th. Hopefully by the end of, there's a good chance that we could be to April by the time we get there. So keep your eyes out for that. That's all wonderful news. The other wonderful news is, again, the eligibility. And this is great news, especially for me, because I no longer have to frantically be looking every single day to see what category of eligibility is opening up today. That has saved me countless minutes. So that's great news. I hope everybody, can get their appointments. Remember the travel advisory. The travel advisory that the governor announced via a press release, a press conference, that the travel advisory for domestic travelers would be going away in the fact that you no longer have to quarantine upon returning to New York from domestic travel. Remember, domestic travel includes travel to all 50 states, all U.S. territories. So if you're going to Puerto Rico, you can go there and you don't have to quarantine upon returning to New York after April 1st. But there's some difficulties here. One, there's been no executive order or updated guidance issued at this point effectuating this change in the travel advisory. The reason that's important is there are reports of certain counties throughout the state that are saying if nothing comes out by April 1 that officially designates this change in the travel advisory, then we're not going to follow this press release. We're going to follow what the actual guidance says, what the actual executive order says. So it could very well, if we don't see something come out by April 1, we could have discrepancies throughout the state as to, you're traveling into one county and you may be told that you have to quarantine after traveling to New Hampshire That is obviously not good. It makes planning very difficult, but hopefully we'll see updated guidance. Hopefully we'll see an updated executive order before April 1. Of course, we will let you know as soon as that happens. The international travel advisory will continue, and the quarantine is still required, and it's different now. Remember, we went over this a few weeks ago, but it's worth repeating. You either have to quarantine for 10 days upon returning from international travel, or 7 days, so long as you take a test with 3 to 5 when you return within 3 to 5 days. That is a change from what it was before. Also, there's no essential worker exception for international travel. That's no ifs, ands, or buts about that. They are really being serious about requiring a quarantine. There are some differences with travel from Canada into New York State. If you have questions about that specifically, you're going to have to talk to your attorney, your favorite attorney, about why that is, because it's pretty complex legal analysis that goes on there. Turning to gatherings, we have more news on that. An executive order was issued yesterday, just codifying this change in the gatherings that's going to be occurring on April 2nd. Events, arts, and entertainment venues. So if you're having an event, you can have an event that's up to 33% capacity if you're indoor, or so long as it's up to 100 people. It's very confusing how this one is written, but just know that the maximum number of people you can have in the space is 100 people if you're indoors, or 33% of capacity, whichever one is less. Okay. 200 people outdoors. And if you're doing testing for one of these, an event, that will be 150 people indoors and 500 people outdoors. So if you're having this means that concerts can come back. This means that if you're doing an art event in the park, you will be able to do that. Just know that there's going to be some more planning involved with it, especially if you're going to go for the upper numbers involving testing. At this point, there's no vaccination exception for events. Everybody has to be tested. You don't get to show your vaccine passport to say that you are fine. Everyone will still have to be tested for these events. That could change, and I do expect that to change, but that is the case as of right now. Finally, we're moving into a little bit something different than COVID. The budget is due this week. The budget will likely be late. We've only seen one bill introduced today, and it looks like it's going to be late. But marijuana legalization is likely going to pass, perhaps by today. It will be passed. It's moving through committees today, so it remains to be seen if it will be taken up by each legislative body, but it's coming, and it is coming in the current form that it's in. The big picture overview, again, it's moving through these committees. Mike is going to talk about what it means for employers, and what it means for your employees right up after me. I'm just going to walk through really quickly overviews of the bill. What to do: people over 21 and over can purchase, consume, and possess cannabis. You can publicly carry around up to 3 ounces of cannabis or up to 24 ounces of a marijuana concentrate. Localities can opt out of retailer sales or cannabis cafes. But if a locality does that, they won't receive the tax revenues from the bill, which are significant. And I'll talk about on the next slide, don't worry. And also, localities may prohibit publicly smoking in certain areas. So think about like a park, and you can't have, and compare that to cigarettes, right? You can't smoke a joint in a brewery, for example. The only place that will be able to do that indoors will be these cannabis cafes. There will be no smoking allowed at work, school, or in a vehicle. That is important as well. At home, people may store up to 5 pounds of cannabis you may grow, every adult may grow 3 mature plants and 3 immature plants. So you can only have 3 fully grown at a time. But before that can happen, there must be regulations that come out. So that's not an immediate one that can happen. Regulators have 18 months to set up the regulations for adult use cannabis, for the sale of cannabis in New York. So that will be a long-term thing. Remember, in 2016, marijuana legalization passed in Massachusetts, and you weren't able to buy marijuana in Massachusetts until like 2018 or 2019. It takes a long time for this to come into effect. Same thing in Illinois. Taxes, the way it's split up is 9% goes to the state, and then you have 4% local tax, with 1% going to the county, and then 3% going to the city, town, or village where the purchase is made. Driving tests. In the meantime, DOH is going to, the Department of Health will be developing and certifying a test to use to test a person's inhibitions while driving. There will be an expungement of marijuana convictions in New York State, and that will be happening over the next 2 years. And then finally, looking at licenses, 50% of the licenses for retail sales of marijuana are to go to WMBEs, that's women and minority business enterprises, service disabled veterans, and financially distressed farmers. I will now kick it over to Mike to talk about what that means for all of you.
I imagine the Q&A numbers are going to be spiking.
They're yeah, they spiking. Just did.
we're going to hit triple digits here. And frankly, just drafting off one of the things you mentioned, the DOH is supposed to put together some sort of test to test impairment. Let's see what they come up with, because currently there isn't one, and this is clearly going to be an issue when it comes to employment. So as far as how this impacts hiring and keeping people that have tested positive for marijuana or smoking marijuana, et cetera, the question, of course, is, Mike, do I need to keep this person? Do I need to hire this person? And as anybody that knows me knows, my answer is always 2 words. It depends. So let's get to it. So what this bill does is revise labor law section 201D. And that's not a section that rolls off the tongue. It's not one that you normally hear about very often, because it's one that protects recreational activities outside of work. How often do these things come into effect? Normally we're talking about discrimination, harassment, retaliation based on a protected class. Well, this New York State law, 201D, protects the use of consumable products before or after work, and protects an individual's legal recreational activities outside of work. And it makes it unlawful for an employer not to hire somebody or to discipline or terminate somebody based upon those activities. And so what the marijuana bill does is insert cannabis into those provisions. So it will be unlawful once this is signed to discriminate against somebody, to take an action against somebody for, the magic language here is their legal use of consumable products, including cannabis, in accordance with state law, outside of working hours, off of work property. It doesn't allow the smoking of marijuana on work property, unless, there's exception to everything, unless this is something where it is medical marijuana, because one of the things this bill does is allow not just oral medical marijuana, but smoking medical marijuana. But that's another issue. We're just talking about non-prescription recreational marijuana. So it doesn't allow you to take an action against an employee for doing that outside of work hours, outside of working time. And you say, well, that's great, Mike. So if somebody's smoking on the job, I can fire them. Terrific. What if they had some gummies the night before? What if they smoked before work and here they are at work? Can I take action against them? And once again, the answer comes down to it depends. So there are 3 exceptions to this. So it says that an employer won't be violating this provision if the employer's actions are required by some other state or federal law. So let's say that you have security guards, and by the federal requirements or state requirements, they cannot test positive at all. Well, then you go by that law. Let's say that you have a federal contract, and if you have your contractors or people that are doing work under the contract test positive, that you'll lose your contract. Okay, you can discipline or discharge the employee in accordance with that contract and what's required to do. Oh, there is one more exception. So if the employee is impaired by the use of marijuana, and here's the magic legal language, meaning that the employee has specific articulable symptoms while working, and it's not just the symptoms, it's the symptoms that either decrease or lessen the employee's performance, or those symptoms interfere with your obligation to provide a safe and healthy workplace, then you can take action against the employee. So of course, this raises the question, what if I have an employee and they show up to work smelling of marijuana, their eyes are bloodshot red, but they're not acting in an impaired fashion. They're not moving slowly. They're not, laughing at my jokes. And so this is somebody that's sober as church on Sunday. And can I take any action against this employee? Of course, we are anxious to get any guidance or regulation on this to aid in that. And to the extent that Department of Health comes up with a magic test that would be able to say, hey, if somebody has this level of THC in their system, they are X amount impaired, that would be incredibly helpful. So there's no language in this bill that covers drug testing itself. So I got a question yesterday about, what about pre-employment drug testing? And frankly, I mean, this language is when the employee is on the job. Once this law goes into effect, I don't see anything in this language that would allow you to say, we're not going to hire this person because they tested positive, unless there is a federal contract or some other state or federal requirement that doesn't allow you to hire somebody that has a positive test for marijuana. So again, very preliminary, but that's how we're reading it. And with
Thanks,
that,
Mike.
I think, oh, no problem.
Yeah, I just to amplify one of your points. I mean, the language of the statute is a little bit, at least in my mind, confusing in the sense that, I mean, clearly you need to be able to demonstrate impairment based upon articulable suspicion. We don't really have testing right now. Who knows if and when we'll get testing that demonstrates that. But that second piece that you're alluding to me, is very unclear. Whether an employer may be able to make the case that, impairment inherently, affects the performance and the safety. And so I think that's the area where we'll look to see guidance, perhaps regulatory guidance, perhaps agency guidance and court guidance, because this is going to be a mind blower for a lot of people. And it's not apparent to me and maybe to other people that people can make the case that they're under the influence, and yet there's no impairment to their performance in most occupations. So I guess we'll just have to see.
Absolutely.
All right, we're running a little bit late, but we did want to give you one more update here. Paul Bueller's been following the unemployment updates and has got some additional information for us.
All right, thanks, Pete. I know we're short on time, so I'll try and hit this really quickly. We've got basically two updates that I wanted to provide for you. Last week we spoke about the unemployment updates and provisions from the American Rescue Plan, and today I want to talk about two that are New York State specific. So the first is related to unemployment insurance taxes. So this applies to all of you guys that are not self-insured, all of you that pay into the unemployment insurance tax system. If you recall, in January, and I've spoken about this several times previously, the Department of Labor issued an order saying we're going to take all of the unemployment insurance charges that we normally apply to employer accounts. We're going to, dating all the way back to March 9th, 2020, we're going to remove all those charges from employer accounts and charge them directly to the general account. So there was no impact on experience ratings, and until further notice, there will be no impact on experience ratings. What the DOL neglected to tell all of us was that this would still impact unemployment insurance taxes. So what they did was experience ratings remained the same, but because they have to pay for all those claims that have been charged against the general account, they've increased the minimum unemployment insurance tax rates. So in the past several years, I know this was true in 2019 and 2020, the lowest unemployment insurance tax rate that an employer could achieve was 0.6%, 0.6%. And that was for those of you that had incredibly low experience ratings, did a great job with employee turnover. This year, Department of Labor has implemented a very increased number. Now the lowest unemployment insurance tax rate that a very low experience rating employer can achieve is 2.1%, and it goes all the way up to nearly 10%. So what this means, practically speaking, is your experience rating remained the same as last year. There was no impact on experience rating from all of the pandemic-related unemployment insurance charges, but your tax rate definitely went up. This is, I think, pretty unfortunate, especially for those of you, like I said, that pay into the unemployment insurance tax system. There isn't a lot that you can do about it right this second. I think the thing to do right now is you got your bill, you want to pay it on time, because there are significant penalties for not paying it on time, and there are also technically criminal penalties, misdemeanors and the like. So what I would advise you all do is pay now, look at your rate, look at the taxes that they're asking you to pay. If they're not right, challenge it later, but pay now. Those of you that are self-insured get a free ride actually on this, because you don't pay unemployment insurance taxes, you don't have an experience rating, your rate didn't go up, and the unemployment insurance, the order canceled all the charges against you, applied them to the general account, and now unfortunately that's being paid by all the for-profit businesses. So if we can move on to the next slide. The other big update out of the Department of Labor related to unemployment insurance benefits was they changed the criteria for partial unemployment insurance benefit eligibility. So what we've got up on the screen here was the previous eligibility criteria, and it was for individuals who earned less than $504 per week. And depending on their weekly work schedule, they were eligible for some fractional unemployment insurance benefit. So someone who did not work at all in any week, they would get, whatever their maximum unemployment insurance benefit amount is, up to that $504 per week. And then, of course, right now there's the extra $300 under the American Rescue Plan. The number of days that they work in a week, if that increases, they can get a reduction in their unemployment insurance benefits. So you work 1 week, 25% reduction, 2 days, 50% reduction, et cetera. So that was the existing framework. And if we can flip to the next slide, this is what the DOL changed it to. So now it's an hours-based approach. So an employee who works no hours per week, up to 4, is still able to receive full unemployment insurance benefits up to that 504 plus that additional 300 under the American Rescue Plan. And then as they work more hours per week, they're supposed to report that to the DOL, but they're supposed to report it as number of days worked, because DOL hasn't updated their system to accommodate this yet. But what it means, practically speaking, is that an employee can work up to 30 hours per week, irrespective of the number of days that they actually performed this work, and still receive 75% of their unemployment insurance benefits. I've gotten a lot of questions about this. I know this is particularly relevant to you guys who have, let's say, seasonal employees that you hire part-time over the summer, things like that. And a lot of employees are, especially these seasonal folks, are wondering, how is this going to impact my unemployment benefits? Should I go back to work? So I wanted to give you guys this update so you can understand, especially for those seasonal and part-time folks. This is how DOL is calculating partial unemployment benefits. So if you want to hire somebody back part-time, it doesn't matter the number of days that you schedule them to work. They can work up to, for example, 20 hours per week and still receive half of their unemployment insurance benefits. They could work up to 10 hours and receive 25%. The one caveat here is that DOL has also said they're going to cap the number of hours that go into this calculation that are worked on a single day. So the maximum number of hours that an employee can work in a single day And then it'd be factored into this per week analysis is 10. So if someone works, for example, a 12-hour shift and they only work 1 day per week, that gets reported to DOL as if they'd only worked 10 hours and only 1 day. So I realize this is incredibly confusing, incredibly annoying. It will be much more difficult for the people actually certifying for benefits. So that's what I've got, guys.
Thank you, Paul. And thanks everyone for being with us. I understand that our invites periodically need to be refreshed, and we'll be doing that. The webinar series is continuing for the foreseeable future. So look for that if you haven't signed up for it, or if it looks like your calendar it's going to run out. It's not. Look for those invites and refresh. Thanks for being with us today and every week. We'll be back here next Tuesday. And in the interim, please take care and stay safe.